Have a good day. Thank you. All right, we'll call the next case, PEREZ versus MCCLISH. Take any side you want.
We usually decide beforehand which has the winning side, but we don't tell the attorneys that. So.
Yes, you can come on up and just let opposing counsel kind of get settled in and get his papers. That's all right. Get comfortable. Would you like to reserve some time?
I would, Your Honor. 4 minutes for rebuttal.
Okay.
And good morning. My name is Luis Gracia. I represent the plaintiff below, Mr. Perez, in this matter. We're here on an appeal for a motion for a new trial that I filed and was denied after a trial in a auto accident case. The facts below were really not that contested. On June 22nd of 2005, my client was involved in an accident with the defendant, Ms. MCCLISH. She admitted that she caused the accident. It was her fault. We presented records, introduced medical records, some of them jointly, as to what had happened at the scene of the accident. An ambulance was called. Mr. Perez was transported to the hospital. 2 days later, he returned with having abdominal pain. Treatment was provided then. And then he continued to treat for injuries that he had sustained, of course, we were arguing were related to the accident. The jury was instructed as to the definition of negligence as a legal cause, but somehow at the end of the trial, and we had a verdict form, there was an interrogatory verdict form, the jury came back with the no as to the question of was the negligence of the defendant a legal cause of injury, loss, or damage to the plaintiff. We moved for a new trial, believing that that particular verdict was clearly against the manifest weight of the evidence. Indeed, opposing counsel in his closing argument admitted that there were items and damages that should be awarded. I claimed that all the medical bills obviously should have been awarded.
Was the jury told about the PIP set-off?
Yeah, absolutely.
Okay. And so would it be reasonable to conclude that perhaps the jury thought that everything was just set off by PIP and there was nothing to award?
That's the only thing that I can actually somehow surmise from this, because we really do not know why is it that the jury did it. However, that question, Your Honor, would have been in a different item. That question would have been to the amount of damages, not negligence as a legal cause. And I think that all the cases, including ones from this district, are pretty clear that at least the diagnostic testing, they have to obviously be awarded. In this case, it's clear that for some...
Is diagnostic testing always awarded when the jury finds that there was no causation as to damages?
Correct. In this case, however, if there's no causation as to the damages at all, one can make that argument. In this case...
Wasn't that what the jury found, that there was no causation as to the damages? She may have breached the duty of care, but there was no causation as to the damages, that the breach of that duty didn't cause any damages?
That was the finding, which we believe is clearly against the manifest weight of the evidence. Clearly.
Well, my question to you is, isn't there case law in the state of Florida and elsewhere that says that if there's no causation as to damages, you're not awarded anything, even if it's diagnostic testing?
And that would be true. Remember, the question here is whether the verdict was against the manifest weight of the evidence. When you have opposing counsel himself conceding that these items should be awarded, and obviously we have no contradictory evidence, the jury cannot simply disregard the evidence and come up with a verdict like they did, which frankly was unexplainable. Now,
Well, your client claimed that you went to the ambulance, had bruises on I guess, the wrist and elsewhere, stomach hurt, and the back and neck was what was really argued about at trial, and they rejected that. You're not contesting that, correct?
Mostly the back. The problem that I have with the case, and this is the importance in my view of the case, is that I do not know what is it that they rejected.
Okay.
Because when we have, I'm sorry, Your Honor.
Let me ask you this.
Sure.
As far as the medical bills, you said you asked for them all. If you left out anything related to the back and neck, and you're just talking about the wrist, and the bruises and the emergency room, the ambulance, et cetera, how much did those add up to?
It would have been, the total bills would have been like around $10,000 something, I believe.
Leaving out the back and the neck?
Yeah, correct. Well, the neck, opposing counsel admitted that he injured, but it was non-permanent. That was the issue.
Right, so you're saying the emergency room visit, the ambulance, the x-rays, MRIs, et cetera, were about $10,000?
That's correct. And the PIP offset was a little bit less than $4,000.
Okay.
Correct. So, and that's why in the motion for new trial, I was completely confused because I thought that counsel wanted like a double offset. I did not understand the argument, and it's because I felt I was confusing it. In other words, they were trying to...
Are you saying that simply because opposing counsel told the jury that, that these damages should be awarded, that the jury is bound by that?
Not only that, Your Honor, but if there is no contradictory evidence whatsoever, I think that this court has made it clear that the jury simply cannot arbitrarily reject it. They just cannot on their own say, okay, well, we're just going to go ahead and reject it. In this case, obviously, they have the medical records. It's clear that Mr. Perez suffered injuries that required him to be transported in an ambulance, that there was diagnostic testing.
But the jury said that whatever injuries he suffered were not caused by the accident.
They did. That's what we're saying, that it was against the manifest weight of the evidence. Correct.
Was there a request for a directive verdict on that issue?
Did not request it, Your Honor. I had a couple of reasons. One was strategic, I have to admit. The other one was that I felt that the evidence was really clear, and to that point, my argument was confirmed with counsel, confirmed, and told the jury what I already basically had told them. That they were, in fact, I even said, the fact alone that Mr. Perez was transported in an ambulance from the scene of the accident to the hospital in and of itself means that the negligence of the defendant caused damage, loss to my client. So,
well, by not asking for the directive verdict and making a strategic decision, and I assume your strategic decision was to try to increase your chances of winning on the major issue of damages, the back and neck, I mean, that would seem to fall pretty much within the fact pattern of Martin. Would you agree with that?
I do not, Your Honor, and let me tell you why real quick. In Martin, the determinative factor was the waiver. Plaintiff's counsel told the jury.
All or nothing.
All or nothing. They invited it. He invited it. I think that this case is Peek versus Stevens. I think that Peek is absolutely on point, where the court specifically said that after the zero verdict, when there was clear liability, we cannot make the determination that the plaintiff is entitled to only the diagnostic medical expenses, nor can we assess what the damages should be. I believe that is the correct standard.
Chris Martin criticized Peek.
Correct. And frankly,
I don't know if you saw who the judges were on Martin.
I absolutely did. And I worked with this very, very carefully because I know who the judges were. But I think that in Martin, I think that which, by the way, I believe that the criticism of Peek was clear dicta. And I think that it was basically addressing Reinauer. And I believe that the court might have missed Reinauer. In Reinauer, the jury had two questions. They made findings, clear findings. One was wrong, one was right.
Let me ask you about,
yes.
Let me ask you about Peek. I mean,
sure.
Does it make much sense if it seems in this case that the jury rejected the back and neck? Does it make much, because you asked for permanent injury, you put on, I assume, testimony that's permanent injury, the jury rejected that. Does it make much sense if they made an error on the diagnostic medical expenses for you to get a second bite at the apple on the permanency issue?
I do, and the reason why is because we do not know whether they rejected it. Remember that in this case, Your Honor, we had a verdict form. There was a questionnaire. They could have assessed that. They could have. We have the classic case of the negligence is legal cause, the amount of the medical bills past and future. We also had the matter of the permanent injury. The jury could have done that. They didn't. This was completely unexplained, just like in Peak. We have no way to explain it. So basically, the way of what opposing counsel was arguing was, okay, if the case is remanded down, but let's not remand it down for the full damages, it is my belief that by doing that, it will be this court and not the jury making that finding.
If we were to decide that Martin is better law than Peak, what relief would you be requesting then?
I will still ask for the case to obviously be remanded down if the verdict is clearly against the manifest weight of the evidence. I still believe, however, that the way the jury verdict reads, the form reads, it's practically impossible for one to then impose or limit my question of damages, because again, in that way, even under Martin, it would be the finding of this court and not the finding of a jury. I think I'm at 10 minutes now, Your Honor, may I?
I just want to make sure that I understand your argument is that because they told the jury in closing argument that these expenses should be paid, and the concession by them in closing argument essentially requires the jury to make that award. And despite the fact that they came back with a finding that, well, we don't think any of these damages were caused by the breach of standard of care.
Opposing counsel's closing argument is one element of this. First, we have the factual basis itself. An ambulance, medical treatment, and then, of course...
Well, here's what's bothering me about that. If a jury concludes that there was no causation as to damages, I don't think that you're entitled to anything. I don't care whether it's the ambulance ride. I don't care whether it's diagnostic testing. It doesn't matter. If the jury comes back and says that even though there was a breach of the standard of care, that there's no causation as to damages, you're entitled to zero. So my question to you is, if assuming that's the standard here in Florida, then what you have to hang your hat on is their concession and closing argument that, well, you should go ahead and award these bills.
That's one thing, as well as the undisputed nature of the evidence. I mean, they did not present anything to contradict the fact that the ambulance ride, that the medical treatment of the hospital was not related. I mean, it was not only undisputed.
What is it related to?
To the auto accident.
Related to what? The accident? Simply because there's an accident, you're automatically entitled to your expenses for the medical ride to the hospital and the diagnostic testing? What if there was a finding that there was no breach of the standard of care?
I'm sorry, Your Honor, breach of the standard of care.
What if there was a finding that there was no negligence at all? That there just simply wasn't any negligence? You still get your ambulance ride and your...
Certainly not. There's no liability. In that case, it would be...
Well, you can only establish liability for damages if the jury finds that it was caused by the breach of the standard of care. If there's no causation, you're not entitled to anything, are you?
And I would agree. I would agree with that. In this case, it's more again to the manifest weight of the evidence. What evidence did we have for the jury to actually reach that? We had the accident. We had paramedics. We have medical records that were involved. The treatment of them at the... And
then you're saying that they conceded...
And then they conceded on top of that. Frankly, to be very honest to the court, I don't know what else to show to prove that there was, in fact, legal cause of injury and damage to my client. I really don't know what else to show. I mean, if the opposing counsel himself is admitting it, that's an issue.
Well, simply because he concedes in closing argument that the jury should award the damages, can't the jury just disregard that too and just say, we don't agree, that anything should be awarded and that there's no causation anywhere and that zero is the appropriate verdict?
I think that this court has ruled in the past that it's called PATRICIA of Orlando. When the evidence of permanence or causation is undisputed, the jury is not free to simply ignore it or reject it.
I'm talking about the concession during oral argument.
The concession
is that enough? I mean, if he gets up, but the jury says, well, we looked at the evidence and we don't think there's any causation at all, period, and he gets up and says, well, give him these bills. is the jury bound by that concession?
And that is added to my argument, Your Honor. In other words, basically, the jury is considering my argument, my view, and then you add the concession. That's the hypothetical, Your Honor?
Well, no, I'm asking you, is the concession enough in and of itself to require the jury to award the damages?
In an adversarial proceeding, I believe it is. What else
You
is?
think it is?
I don't know what else is to show. For example, if
They conceded liability, right?
no liability was admitted.
That's what I mean. The other side conceded liability.
Yeah.
So you weren't required to put on any evidence of liability.
No, sir. No, sir. They admitted liability.
Did that come in by summary judgment order, or was that just something that the jury was instructed at the beginning of? Or?
Did you correct? They filed, opposing counsel filed. I'm sorry.
My question is, if it's reasonable for the jury to conclude that there was no causation at all, but he gets up in closing argument and says, well, just give them the bills anyway, is the jury bound by that concession? If we look at the evidence and say, well, you know, there was enough here for the jury to say there was zero causation. My question to you is, is the jury bound by his concession in closing arguments, and must the jury comply with that concession and give him the money anyway?
I think that I would have to say yes, Your Honor. I'm trying to figure out a fact pattern where that would not be true. In other words, where I'm arguing that the medical bills are related. Opposing counsel gets up and says, yeah, the medical bills are in fact related. I don't see how the jury gets to arbitrarily reject that. Okay. I don't even see that they have, frankly, I don't see it at all. The second part of this, which is the part of if the court decides to remand, the part of the what is it to remand, and that's why I believe that peak controls, and it should be basically the whole case down. For my whole damages, being that we simply do not know why the jury did this. There's no way to find out. And in this particular case, just like in Peak, I don't believe that the court should be assessing the damages. I truly believe that the correct way to do this will be to remand it down on all damages. I noticed that my 4 minutes are going down. Thank you.
Thank you, counsel.
May it please the Court. Dale Goebel for the defendant, Patricia McClish. Your Honors, respectfully, the question presented by this appeal is, did the trial court abuse its discretion in denying a motion for new trial?
Let me ask you this. Would you agree that the evidence was undisputed, that the plaintiffs suffered at least some injuries or some damages as a result of this car accident?
Your Honor, I would concede that, and I did concede in closing argument, that the trip to the hospital, the initial trip to the hospital, was recoverable.
And the undisputed evidence would support that?
Your Honor, frankly, I don't think so. And the reason is there was no medical testimony whatsoever to tie those trips to the hospital to the accident.
Why did you make the concession? Why did you tell the jury to give them the money?
Your Honor, because, frankly, it seemed reasonable. It's a strategic move by any counsel in closing to persuade the jury.
You were trying to show the jury that you were being magnanimous and that you weren't trying to be greedy and to give them something?
Exactly, Your Honor. You could say...
You're saying that was a trial strategy on your part?
Certainly. And you tell the jury and you show the jury that you're being reasonable and that these are damages that seem to be related to the accident, and you're certainly free to award those.
Well, and he had certain bruises and contusions from the accident.
That's true. True. And so it certainly seemed reasonable to say that those could be in that...
And that was undisputed?
Yes. Well, it's in the records. You're right. It's undisputed. It was in the medical records. Now, what was disputed... Now, frankly, here is the situation. There were certain bills that were incurred within a few days after the accident. There were bills on June the 22nd, 2005 for the emergency room visit and the ambulance transport. And there were bills then on June the 24th, 2005 for the plaintiff's visit to the hospital for his stomach pain. Now, what the jury was free to decide, and what the jury apparently did decide, was that the visit on June the 24th was related to the plaintiff's constipation, or extreme constipation, obstipation. Now, there was a directed verdict on that issue, which was unopposed by counsel, where the court directed the jury that the obstipation was unrelated to the accident. So the jury was certainly free to determine that that visit in its entirety was unrelated to the accident and therefore unrecoverable.
What was the amount of the medical bills for the first day only?
For the first day only, you had $789.63 for the hospital bill, and I'll have to do the math, Your Honor, $789.63. Then you had the emergency physicians, and there's 2 dates of emergency physicians. I don't have it broken out, but the total of 2 dates, June the 22nd and June the 24th, is $536. Then you had the ambulance for $424, and that's it. So between those bills, you have $900 and $700, about $1,700.
Okay.
And those, in that first date of service, minus, so it's less than $1,700. Call it $1,500 if you divide that bill for the emergency physicians by 2. Certainly the jury was free to decide that the amount that was presented for the PIP set-off, which at this point was $3,985.35, based upon a ruling of the trial court related to other medical bills that did not come into evidence. That $4,000 approximately was more than sufficient to set off the amount that the jury determined was actually related to the automobile accident in this case.
The opposing counsel said that it's undisputed that there were some damages caused by the negligence. And you're saying that that's not necessarily the case.
I don't think that is necessarily the case.
Okay, explain to me, if I was to go through this record and look, where I'd be able to go to the record and say, okay, well, here's where the jury made their decision that, that there was no causation here. This is what I see were the lack of evidence in the record as to causation.
I appreciate that, Your Honor, and the point is that, and I think the point that Your Honor is making is that one suing for personal injuries has the burden of proving the necessity and reasonableness of the charges for medical attendance and treatment. If Your Honors look through the transcript, I don't believe that there is one iota of evidence related to the transcript that is submitted to this court. I don't think there's one iota of evidence that relates to that first day of treatment at the hospital. I don't think there's any medical testimony whatsoever related to that first day of treatment in the hospital. The only evidence in the record are just the medical bills themselves and the medical records themselves. The jury was certainly free to look at those medical bills and records and make a determination for itself as to what was reasonable, necessary, and related.
Well, let me just be clear, though. You concede to the jury that he's entitled to be compensated for day one of the accident, the trip to the hospital and the hospital bill and the ER doc, the $1,500, $1,600, $1,700. You concede that. Your argument, if I understand you correctly, is that he was fully compensated for that by virtue of the PIP set-off.
That's correct.
So I just want to be clear. You're not backing away from the concession. You're simply saying, accepting the concession, the jury was free to say, well, he's gotten more money than he's due anyway, so we're going to award zero. Is that?
That's entirely correct.
I'm trying to understand if you're backing away from the concession and saying that the jury can just disregard it, or if you're saying they were obligated to accept it, they accepted it, and he got all the money he was due.
I think you're asking me two questions, and I'll answer both. Number one, I'm not backing away from the concession. I made the concession, I made it for strategic reasons, and obviously I believe that it was successful. The second question that Your Honor is asking is the jury bound, as Judge Sawaya asked, by a concession made by counsel during closing arguments? I don't think the jury is bound by that, just as the jury is not bound by any argument that counsel makes in closing arguments. Closing arguments are just that.
Well, technically, if the jury accepted the undisputed evidence and accepted the disputed evidence in the light most favorable to you and accepted your closing argument, then what they should have done is on the jury verdict said, yes, there's causation, but there's no damages because the PIP exceeded what they were entitled to.
And that's essentially plaintiff's argument here, or appellant's argument, is that although zero damages was appropriate, the jury should have arrived at zero damages a different way. And I do not think that the judge's denial of a new trial on that basis constitutes an abuse of discretion. Certainly, it would be harmless error to say that a zero verdict is a zero verdict, no matter how the jury arrived at it. And certainly the jury could have said, as counsel submits, that they could have said yes on part one and then zero on the remaining part of the verdict form. Question number one was the negligence of Patricia McClish the legal cause of loss, injury, or damage to the plaintiff? Now, first of all, what one interesting question is the term damage is undefined. Does damage mean a scrape on the arm? Does damage mean the most slight paper cut on your finger? The question is, what is damage? So the jury could have said, you know, these little abrasions we don't really consider to be damages. You know, this minor bruise that you sustained, we don't really consider to be damage. So the jury could have looked at it from that perspective and said, you know, these extremely minor injuries that Mr. Perez sustained in this accident, we don't consider to be damages. So we are not awarding any loss, injury, or damage to the plaintiff, ALADINO Perez. So that certainly could have been their conclusion at the end of the day. And even if they didn't, Your Honor, if they were to say yes to question number 1, and then number 2, the next question was, what is the amount of any damages sustained by the plaintiff for past medical expenses, the jury could have said 0, and you would have arrived at the same result. So getting back to the primary question, did the trial court abuse its discretion in failing and denying the plaintiff's motion for a new trial? I believe the answer to that is absolutely not, where there is no damages that were proven to the plaintiff, and where the medical bills, the evidence showed that the medical bills that conceivably were related to the accident were paid. So I think that respectfully resolves that issue.
What would your argument be if counsel were to say, well, PIP only covers 80%, so those bills would only be covered at 80%, leaving the 20% unpaid?
Well, the jury could have decided that only 80% of those bills were related to the accident. And the second part of that is there was no direction to the jury.
There'd have to be some finding of comparative negligence for them to do that, wouldn't there?
I don't believe that's true.
You don't think so?
No, I don't believe so. I think the jury could have looked at it. For example, and I think the prime example of this is that June the 24th bill for the treatment at Fish Memorial, where the plaintiff went for the treatment of his constipation. The jury could have looked at that and said, well, you know, 90% of that
The constipation
was
wasn't related, but the rest of it was.
right. And so that was certainly a finding that the jury could have made with respect to all of the bills. The jury could have found that for any of the bills in this case. So the question, and I think, you know, I keep coming back to this, is, number 1, did the plaintiff prove reasonableness, necessity, and relatedness? No medical testimony whatsoever. Secondly, did the trial court abuse its discretion in denying a new trial? Under the facts of this case, where concededly by the plaintiff, there could have been a finding by the jury of no damages under this situation here, I certainly don't believe that that could be considered to be an abuse of discretion.
All right, sir. Thank you so much.
Let me ask you this. If the jury had answered yes for the first question, there's causation, and then the second question put 0 for damages, would you have had a viable argument for either a new trial or in front of us?
Absolutely, and the reason why is because I think Judge O'Finger pointed the issue. 80% is paid, 20% is remaining, that by law they have to pay.
All right, but counsel argued that the first day medical bills added up to $1,700, and that your client received PIP of between $3,900 and $4,000. So if the jury was to accept that, why couldn't they have said 0? That you got, you know, PIP payments for stuff that wasn't covered.
Well, I think we have a couple of issues. First, remember that we were disputing the amount of the medical bills that were argued to begin with, okay? And that's one of the things that I was arguing in a motion for a new trial. I felt that what counsel was trying to do was get 2 offsets. We had a remaining amount that is outstanding at 20% that the particular defendant had to pay. The problem, Your Honor, here is twofold. First, this issue of what PIP paid or did not pay goes to question number 2, amount of damages, no legal causation. And the second thing that we have is that this issue of obstipation, which came out of nowhere.
Well, opposing counsel, generally when damages are divided up like that, there's comparative negligence. But he was saying that, you know, the jury could have looked at the treatment that was given and said, well, the treatment for the constipation didn't have anything to do with the accident, so maybe that's the 20%. What's wrong with that?
Two things are wrong. The first thing is that there's no evidence that my client was treated for obstipation. 0 evidence. The obstipation was simply a finding on a CT scan. The record shows that the diagnosis The releasing diagnosis was motor vehicle, this is on the 24th, motor vehicle accident, muscle strain, contusion, scrapes and abrasions. There was nothing else observation. This was an argument that came out of the proverbial blue because that happened to be the...
That's probably what happens when you don't put on medical testimony to explain, these bills, what happened, what the treatment was, what was caused by the accident and what wasn't, and that sort of thing. I mean, all you did was just introduce the bills.
Well, and I had my client, and at least the reasonableness of it, this court has said it can be introduced by way of the plaintiff, which he did.
Could the jury have appropriately found that only the medical bills for the first day were awardable?
I cannot see how that could be, I cannot see how that's possible. The obstetrician issue, by the way, that CT scan was of the pelvis and the abdomen. They were concerned, and that happened to be the finding. I think this court has made it clear that medical treatment, diagnostic testing done to determine the etiology of injuries is compensable. Whether or not the finding itself, it has to be related or not. So I do not, and by the way, the visit itself, counsel himself said on the visit, stated, I will submit to you that there's $700 in that bill, the emergency room, that should be awarded. It seems reasonable. If he thought he was having some stomach pain, it could be related to the accident. Yeah, that makes sense. Go get checked out, which my client did. That's exactly what happened here. That treatment was related to the accident. The finding on the CT scan, which obviously was not, is a completely different issue. I admitted that the observation was not related. Of course I did. That doesn't mean that the treatment itself was not and should have been compensable. So basically,
let me ask you this about the remedy. You're arguing that we reverse this and send it back for a new trial on all the damages? When we're talking about just certain categories, for example, the ambulance ride and the initial visits to the hospital and that sort of thing, and those are the only damages that really are in dispute here? But your argument is that we should reverse this and send it back for a new trial on all categories of damages?
I do. And Judge, I figure my time has expired. Can I
answer the question,
okay.
And then we'll...
Yes, I do, Your Honor. I believe that Peek versus Stevens takes care of that and is on point on that.
All right, sir. Thank you so much.
Thank you, Your Honor.
Thank you both. Have a great day, and we'll call the next